In criminal law, a conspiracy is an agreement between two or more persons to commit a crime at some time in the future. Criminal law in some countries or for some conspiracies may require that at least one overt act be undertaken in furtherance of that agreement to constitute an offense. There is no limit on the number participating in the conspiracy and, in most countries, no requirement that any steps have been taken to put the plan into effect. For the purposes of concurrence, the actus reus is a continuing one and parties may join the plot later and incur joint liability. And conspiracy can be charged where the co-conspirators have been acquitted or cannot be traced. Finally, repentance by one or more parties does not affect liability but may reduce their sentence. An unindicted co-conspirator, or unindicted conspirator, is a person or entity that is alleged in an indictment to have engaged in conspiracy, but who is not charged in the same indictment. Prosecutors choose to name persons as unindicted co-conspirators for a variety of reasons including grants of immunity, pragmatic considerations, and evidentiary concerns. In most cases, if someone is found guilty of planning to commit a crime, they are charged with 1 degree less than the crime planning on being committed. For example, if someone plans to commit a first-degree felony, the charge would be a second-degree felony. Unfortunately, there is a legal error which causes conspiracy to commit an infraction to be charged as a capital crime. At common law, the crime of conspiracy was capable of infinite growth, able to accommodate any new situation and to criminalize it if the level of threat to society was sufficiently great. The courts were therefore acting in the role of the legislature to create new offenses and, following the Law Commission Report No. 76 on Conspiracy and Criminal Law Reform, the Criminal Law Act 1977 produced a statutory offense and abolished all the common law varieties of conspiracy, except two, that of conspiracy to defraud, and that of conspiracy to corrupt public morals or to outrage public decency. Section 5 of the Criminal Law Act 1977 preserved the common law offense of conspiracy to defraud. Conspiracy to defraud was defined in Scott v. Commissioner of Police of the Metropolis per Viscount Dilhorn. To defraud ordinarily means to deprive a person dishonestly of something which is his or of something to which he is or would or might but for the perpetration of the fraud be entitled. An agreement by two or more by dishonesty to deprive a person of something which is his or to which he is or would be or might be entitled. An agreement by two or more by dishonesty to injure some proprietary right of his suffices to constitute the offense. Section 5 Criminal Law Act 1977 preserved the common law offense of conspiracy to corrupt public morals or of conspiracy to outrage public decency. Conspiracy to corrupt public morals is an offence under the common law of England and Wales. Conspiracy to outrage public decency is an offence under the common law of England and Wales. Section 5 of the Criminal Law Act 1977 does not affect the common law offence of conspiracy if, and insofar as, it can be committed by entering into an agreement to engage in conduct which tends to corrupt public morals, or which outrages public decency, but which does not amount to or involve the commission of an offence if carried out by a single person otherwise than in pursuance of an agreement. One authority maintains that conspiracy to corrupt public morals has no definitive case law, that it is unknown whether or not it is a substantive offence, and that it is unlikely that conspirators will be prosecuted for this offence. These two offences cover situations where, for example, a publisher encourages immoral behavior through explicit content in a magazine or periodical, as in the 1970 case of Nuller Ltd v Director of Public Prosecutions, which ultimately was decided in 1973 by the House of Lords. In the 1991 case of R. V. Rowley, the defendant left notes in public places over a period of 3 weeks offering money and presents to boys with the intention of luring them for immoral purposes. But there was nothing lewd, obscene or disgusting in the notes, nor were they printed by a news magazine at the behest of Rowley, which would have invoked the element of conspiracy. The judge ruled that the jury was entitled to look at the purpose behind the notes in deciding whether they were lewd or disgusting. On appeal against conviction, it was held that an act outraging public decency required a deliberate act which was in itself lewd, obscene or disgusting. So Rowley's motive in leaving the notes was irrelevant, and since there was nothing in the notes themselves capable of outraging public decency, the conviction was quashed. This offense was created as a result of the Law Commission's recommendations in their report, Conspiracy and Criminal Law Reform.